after yesterday's public spanking brought to you in part by Alan Jackson.
Mr. Breenan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it.
It looks like stifling special probiotic Hank Breenan is still on his little power trip from yesterday, and currently in his line of fire is David Yannetti. Hello, 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 and welcome back, roommates, to Alexasrewm, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people who have opinions about all things going on in the true crime community, including this ridiculous motion that was filed earlier today by none other than our favorite special probiotic, Hank Breenan. Now, one can only wonder what exactly is Hank Lynn's motive for doing this, and I do have a couple of theories, as well as some others who have been speculating what this could be, what if anything, if it does in fact pass through, although I don't see why it would. But let's get into the actual motion itself. It's pretty short and sweet. The Commonwealth's motion to compel communications between the defendant and attorney Yannetti stored within the defendant's cell phone data. I mean, talk about attorney-client privilege, right? The Commonwealth seeks all texts, emails, or written communications between the defendant, Karen Reed, and attorney David Yannetti, restricted to those communications that occurred between January 29th, 2022, and February 2nd, 2022. Wasn't Karen Reed's phone seized the same exact day her car was seized, which happened to be the same exact day that John O'Keefe was found on the front lawn of 34 Fairview? So why would they need to seek her phone communications with her attorney if they had already seized her phone at that point? And again, I do have a couple of ideas as to maybe why, but let's take a look at this footnote. Pursuant to a search warrant, the Commonwealth received the contents of the defendant's cell phone. Because of an observed attorney-client communication, the phone data was provided with the assent of the defense to the Attorney General's office, and a court-ordered taint team protocol was implemented. Now, we know how Hank Lynn feels about those taint teams. I mean, when it came to Morrissey's phone, he was like, I don't trust any third party, right? I have to manually go through his cell phone myself. So, the Commonwealth received the defendant's phone data with any privileged communications excised. Given the defendant's public waiver of the attorney-client privilege as it pertains to the defendant's conversations with attorney Yannetti on January 29th, 2022, and the following 3 days, the Commonwealth is entitled to the communications between the defendant and attorney Yannetti for this waived narrow period of time. This seems to be very in character for the way that the Commonwealth has been playing defense for the Commonwealth, right? That's their number one priority right now. Protect the Commonwealth and DA Morrissey's office at all costs. That's the way it comes across to me. I mean, they didn't have any luck with Alan Jackson getting removed pro hoc vice. Could this be a way to get Alan Jackson, Eliza Little, and Robert Alessi removed from counsel because they are under David Yannetti, who is a practicing Massachusetts attorney, removed? I could definitely see that as part of his strategy, whether or not it'll actually work. But it definitely gives the ick factor, which he was already giving me. The privilege holder, Karen Reed, has waived her attorney-client privilege with attorney Yannetti relative to any statements about her collision with John O'Keefe. That's an interesting way to phrase that. During the time of January 29th, 2022 through February 2nd, 2022, which again, if Michael Proctor had her phone in custody, I mean, then she wouldn't be able to communicate with David Yannetti through text. And was she even texting him? I don't know. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. The communications confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them. I've noticed this pattern with Hanklin too, and I don't know if you guys have caught on this, but I feel like whether it's in written form or it's spoken verbally in court, where he says something but doesn't actually deliver any sort of substance to the thing that he's saying. So another footnote. All right, so to ensure that only the communications that were waived are provided, the Commonwealth requests that this honorable court review in camera all text messages and written communications stored in the defendant's phone data for the time between the 29th and February 2nd. But again, it doesn't even quote or say, like, what are these public comments that she's making? And after subjecting myself, unfortunately, I don't know why I did this, I guess I hate myself, to that awful ID Discovery docuseries. I'm on like part 4. This, I believe, he's referring to the first episode where she was trying to figure out, okay, like, could I have hit him? I was, drinking. Everybody else was drinking, and I don't know, like, could I have pretty much everything we've already heard her say in other interviews, right? Her just questioning everything, not knowing, not having any information. But at this point, on January 29th, 2022, the same day that she found her boyfriend dying on the front lawn of some random guy's house, who happens to also be a Boston cop, and tries to literally revive him, she's got questions. And, she's just saying a lot of stuff, asking a lot of the same questions that I think anybody who's in shock, actual shock and horror, Jen McCabe, would ask themselves. So, in support of this motion, the Commonwealth acknowledges and respects that the attorney-client privilege protects privileged communications between a client and his or her attorney. Mass R. Evidence 523 provides. Waiver of privilege. Who can waive? A privilege holder or the holder's legally appointed guardian, administrator, executor, or heirs can waive the privilege. B. Conduct constituting waiver, except as provided in Section 524. Privileged matter disclosed erroneously. I love that word so much. That is such a fun word. Erroneously, or without opportunity to claim privilege. A privilege is waived if the person upon whom this article confers a privilege against disclosure voluntarily discloses or consents to disclosure of any significant part of the privileged matter, or introduces privileged communications as an element of a claim or defense. So that's what he's rocking with, right? These two right here, right? She volunteered because she sat down and did interviews, because I guess Hank Brennan's more preoccupied and worried about how the PR of his campaign is holding up to the public, right? Instead of actually reading through the transcripts from the first trial, coming to court prepared, and knowing what the duck you're talking about. But no, you're just sitting here wasting time waiting for the next ID Discovery episode to drop. Conduct not constituting waiver. A person upon whom this article confers a privilege against disclosure does not waive the privilege if the person merely testifies as to the events which were a topic of a privileged communication, or 2, there is an unintentional disclosure of a privileged communication and reasonable precautions were taken to prevent disclosure. So now we're in the meat of the potatoes. This is the big aha moment for Hanklin. In this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding specific conversations she had with Attorney Yannetti regarding the collision between her vehicle and John O'Keefe. So now you're calling it a collision. But I thought she was facing M2 charges as well, too. Unless that's going to get dropped. I don't know. Maybe that's why he's wording it this way. Maybe they have that up their sleeve. I have seen people also speculate about that. For example, in the defendant's recorded interview with Gretchen Voss on June 20th, 2023, transcript page 105, line 23, this is the question you never said, did I hit him? I hit him. Karen Reed responds, I said, could did I hit him? Which she has said a number of times in a number of interviews, right? She has always said, and very, very adamant about it, could I have hit him? Did I hit him? Is this possible? This was the initial first few hours, right? Once they started getting more evidence, and Steve Scanlon, who contacted David Yannetti and was like, yo, something's not right here. You might want to look into this because I don't think it's all that meets the eye. And they started digging more, and more evidence started revealing itself, pointing in a certain direction. Then it became clearer to her and everybody else, like, oh, yeah, this doesn't seem right. And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's capability there. And I thought, all right, maybe this is what. Maybe I said to my mother, just to go forward a second, they were asking me, what is it like? Did they come out? What was the house like? Attorney Yannetti, Attorney Jackson, Attorney Little were in attendance along with the defendant. I mean, I just feel like, what does this actually say? Like, if you can, because everybody likes to hold on to the fact that, during that first arraignment hearing, when David Yannetti said, oh, it was an accident, right? Because at that point, nobody had any evidence. Nobody knew what the heck was going on. Second, in a Vanity Fair article entitled Karen Read Tells Her Story, Part 1, an unaliving trial in Massachusetts, with the caption, as Karen Read's second unaliving trial looms, she's ready to talk about what she says really happens. Published on October 29th, 2024, which we've gone over in past videos, the defendant, who according to the publication was notably aware that anything she said could be used against her, volunteered a rumor that alleged representations made by the Massachusetts State Police that there is text messages between her and counsel that implicates herself is all right. Look, I know sometimes I'll tweet out something, I'll make a quick typo, and I go back and I edit it. I get it, it happens, we're all humans, but this is a freaking legal document, man. Like, is nobody proofreading anything? This sentence does not grammatically make any sense. Not even, proper quotations here. There's no comma here. Right? And this doesn't even, there is text message between her and counsel that implicates herself is a provable lie. What? How do you even combat that? What the duck does that even mean? Who proofreads this before they file it? So I do have the Vanity Fair article. This is the section of the article they're referring to. I'll link it in my show notes if you want to go give it a read. So Karen Read hired a private investigator and even sought out materials that could prove she was guilty, like security footage from the Albert home. Yeah, where's the ring camera footage, Lally? You would think if it was so cut and dry, this drives me absolutely nuts. If it was so cut and dry, don't you think, especially if you're really for the boys in blue, right? And it's all really that strong, blue is thicker than blood, all of that, right? You would think that everybody on their street, especially the cop, Tom Kelleher, lived across the street, you would think anybody who had any kind of security camera footage would I bet your bottom dollar at least one person did, would be like, oh yeah, I caught the whole thing on my camera. Here you go. Open and shut, done, case, bada bing, bada boo, give me some gabagool. I just don't understand. I don't understand. Show me a video of her hitting John O'Keefe with her car, and then you got me. But until then, I don't know. But Albert said he never installed a camera his wife gave him conveniently, right? I also just happened to not wake up when there were sirens blaring and there was a woman screaming her head off trying to resuscitate a dead man on my front lawn. But, things happen. Nor was there security footage from homes on the street. There will be one of the neighbors, the neighbor of the, quote, Asian house, according to Matt McCabe, that will be testifying in this trial potentially. And that should be interesting. I would love to hear from more neighbors because I'm sure the whole block was like waking up. The homeowner across the street from the Alberts, who works for Canton Police, told Reed, so this is Tom Kelleher, told Reed's private investigator that his camera did not pick up anything from 34 Fairview. Security footage from the library that Reed drove by between 12:37 and 12:39 a.m. should have shown whether her taillight was smashed, but that precise 2-minute time frame of the video was missing conveniently when the Commonwealth turned it over to Reed's team. Commonwealth says they turned over the entirety of the video that the Canton PD gave them, which we now know is absolute, utter BS. Hashtag LOL, no tampering, Helena Rafferty. Reed told me about a rumor that there are texts, so this is what he's referring to, told me about a rumor that there are texts between her and her lawyer in which she implicates herself. Texts that police supposedly read when they confiscated her phone, but that will never be released because they're privileged. So this is what he's referring to. He's like, well, I want those text messages. It's like, well, ask your buddy Trooper Proctor, who just got fired. And who's got, what, state police issued vehicle chilling outside of his house. Proctor, the state trooper himself, referenced an exchange on the stand saying he stopped looking through her phone when he saw messages between Reed and an attorney. He's like, oh, this is too boring. No nudes. Not interested. But Reed and Yannetti each point out that they didn't communicate until after Massachusetts State Police had seized her phone and car, which was the same ducking day that John O'Keefe passed away, well, was unalived, and Proctor decided that Karen Reed was guilty. I didn't even have a cell phone number. This is great. I didn't even have a cell phone number for David until several hours after Proctor left with my phone, Reed says. I never texted him on January 29th. Proctor testifying on the witness stand that he saw texts between David and me is a provable lie. That is what she is talking about. So if you want to quote things, Spanky, it's just a simple copy and paste. Third, in the now airing 5-part docuseries on investigation discovery in HBO Max entitled A Body in the Snow, which is just a terrible frickin' name. I mean, you might as well just change it to A Man Passed Out in the Snow. Written and produced by Jen McCabe. Defendant professes. And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if I ran his foot over? Or what if I clipped him in the knee and he passed out? And or went to care for himself and he threw up or passed out? And David said, yeah, then you would have some element of culpability. So that's how I thought about things for about 3 days, which she did say. So that's in the first episode, a little bit past the halfway mark, if you can stomach it. So that's where I guess he's getting the 3 days from, which is interesting because then February 3rd rolls around and who enters the chat but Steve Scanlon. The privilege holder is the defendant, and the defendant intentionally waived her privilege by disclosing her conversations to a nationwide audience with her attorney. The attorney-client privilege can be waived only by the client. See in the matter of a John Doe grand jury investigation, 408 Mass 480, 1990. So I'm going to pull this up actually for you so we can take a look at it. In John Doe, the court emphasized that an extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. What the heck does that have to do with what does that have to do with waiving attorney-client privileged? What? In John Doe, the court emphasized that an extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. Like, again, what does that have to do with her waiving? Is he saying, like, oh, she just, ignored the advice of David. I mean, I'm trying to figure out how that pertains to this particular portion, unless I'm missing something. Again, I'm not an attorney, but I mean, that just like, it's very broad. And like that's it. That it's like, that's, he doesn't cite anything from the case. There's no footnote. He just says, yeah, here's a link. Go check it out. Clickety click, Beverly. In between White Claws. In addition to rendering the communications non-privileged, the communications are relevant as admissions and statements of the defendant. These statements are admissible substantively, and Attorney Yannetti's statements to the defendant are admissible pertaining to the defendant's state of mind. So here they go with the consciousness of guilt thing. I believe. So this is where I kind of felt like this is where they're going. They're trying to prove like that whole consciousness of guilt. That's what they were attempting to do with extracting, retrieving text communications between her and Aiden Carney, Turtle Boy. That was during yesterday's hearing, the beginning of that. Holy smokes! If you haven't seen that, I'll link Melanie Little's coverage of that. I think she started off her live stream going over that. That was crazy. And that motion did end up kind of getting granted, but it's not really going to favor the Commonwealth in the way I think that they had hoped. So Turtle Boy also released a article on that today, so I'll link that as well, so you can get caught up to speed with that. But this is what Lally tried to do too last time. He was trying to prove like, oh, consciousness of guilt because she hired a DUI attorney, and therefore that means she thinks she's guilty. And it's like, huh, what? And the judge was like, no, like, you can't. No, just because you get an attorney, Colin Albert, Brian Albert, Brian Higgins, a whole bunch of people in this case have gotten attorneys. So I mean, and where's the consciousness of guilt there? Also, the defendant's admissions and Attorney Yannetti's statements are relevant to challenge the defense's later purported claims of third-party culpability. So there you go. There's the tie-in. Communications have relevance to rebut the defense's potential claims that some other person committed the crimes that caused the death of John O'Keefe. I mean, yeah, how else are they going to put together a defense and tell the truth, expose the truth? That's all it is, right? David Yannetti said it best yesterday. The Commonwealth is essentially trying to hide the ball, and the defense is just trying to expose the truth, and that's it. And they don't want that to happen. Moreover, the defense has suggested that as part of its defense, it is likely to pursue a Bowden-type defense. The potential evidence is relevant to rebut claims of law enforcement contrivance. So I think, yeah, that's it. There's no citing the case law. There's no, I mean, he didn't even include in the footnotes like timestamps of when and where Beverly canola oil can access this starking, breaking admission of guilt in the ID Discovery series. I mean, it's just like, what are we doing here? Definitely could see this being a potential way to get everybody out of the picture, and also to continue the trial, right? Because nobody wants to start April 1st except for Beverly Canola Oil, because she's got big plans in the Cape Cod this summer, guys. She's got big beach plans, so can't interrupt that. Hell no. Bettero had some really interesting thoughts, and a lot of people seem to share the same from the LawTube community. Yes, the motion filed today is the most over-aggressive and offensive I can recall offhand. Statements made to the public by a defendant are what they are, and if relevant, clearly are admissible. I mean, yeah, same thing in Baldwin, too. They wanted to play clips of his interview he did with Dateline, I think, right? But to utilize that as a way to pierce privilege, exactly. and an asserted right to examine communications made by an attorney and a client years ago on a theory that privilege has been waived on all prior communications on the same topic is unheard of. Exactly. It's a fishing expedition. They just want to know. I don't think they specifically care about the contents of like a consciousness of guilt or culpability or any of that. I think they just want to know, well, what else do you know? Who else have you been talking to? Because Hank Breenan's already failed to retrieve phone records between Karen Reed and her family members, right? Nathan Reed, I think Nathan Reed, they were going after bank records. Bill Reed, I think there's probably a lot of different angles to this strategy. And then all this to say is this just feels like very icky. So now not only like should I not talk to journalists, but I shouldn't I also don't know that anything I could say to my attorney, who I've hired and retained to help me protect my rights and put together a defense to make sure I don't end up in the pokey. All of that now could be up for grabs. With that being said, I would love to know your thoughts and theories. If you enjoyed today's content, make sure you hit that subscribe button. Make sure you hit the notification bell so you do not miss the next update from me with this case, and make sure you hit that notification bell because that tells the YouTube algorithm that this is newsworthy news, and all this duckery, it needs to get exposed because they're just going to continue to lie and lie and lie and lie and lie and just continue to infringe on innocent people's rights. Before I jump, I want to make sure that I do this. We got our monthly payout for YouTube, thanks to all you fine folks. So every single month, right now our focus has been the Karen Reed case, just because I'm very one-track minded and I need to be focused. So every month we donate 20% to a cause that this channel believes in. And right now, again, this is justice for Karen Reed, free Karen Reed, justice for Officer John O'Keefe. So we earned $394 this month. So thank you to all you fine folks for donating. And now I'm going to donate 20%. So 20% of $394. Let me just do that math really quick. $78, so we'll round it up. So $80. $80 to the Karen Reed Defense Fund. I'm just gonna, for my personal details, and just for transparency purposes, because this is, after all, due to you fine folk for supporting this channel and tuning in every single week. Boom, successfully donated $80. If you want to donate your own cash, I always share the link in my description box below. Just zoom in so you can see it a little bit clearer because I'm blind. So there you go. So yeah, free Karen Reed. Have a happy weekend. Stay safe out there, and yeah, I will see you all in the next one.